Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Marenholz versus County Board of School Trustees. This case was heard in Illinois Appellate Court, year of 1981. Let's go ahead and jump into the facts of the case. So Marenholz is the plaintiff in this case. They owned a large piece of property, 38.5 acres. They had purchased that property from the Jackmains. The Jackmains had purchased that property from the Huttons. So the Huttons are the original owners of the property for purposes of this deed that we're going to talk about. So the Huttons had 40 acres total. They conveyed 1.5 acres to the school district there. And they said, hey, here's this 1.5 acres. We'd like for you to build a school. We're going to call it the Hutton School. You're going to honor our legacy. And in the deed where they conveyed the 1.5 acres to the Hutton School, they wrote, and I'm just going to read specifically, this land is to be used for school purposes only, otherwise to revert to the grantors herein. So what the court is grappling with here is what this language construes in life estates and in fees. Does this convey a fee simple determinable, or does it convey a fee simple subject to a condition subsequent? And that's what the court grapples with. So the Marenholzes, the plaintiffs in this case, they brought suit claiming that the 1.5 acres that the school district had the Hutton School on was no longer theirs. And that's because the school district was not using the Hutton School for schooling purposes. Kids weren't being taught in there or anything like that. What they were doing now was using the Hutton School as a storage facility is what they claimed. And because they're using it as a storage facility, it wasn't school purposes. And they wanted the land back, right? The Marenholzes don't have the direct claim from the Huttons. So what they did was they tried to say, one, it was passed to them by the Jackmains, who they purchased the property from. And then two, they try to argue that they went to Mr. Hutton, they contacted Mr. Hutton, and they tried to buy that interest from him. And he gifted that to them. So that is kind of the question. There's 1 and 2. 1, do they get this right to the 1.5 acres that the school is on, this reversion right from the Jackmains, and did they in turn get it from the Huttons? Or 2, did they get that right from the Hutton, the heir of the original owners of the property? Do they get that right? So the court grapples mainly with, what does this language convey? Does it convey a fee simple determinable, or does it convey a fee simple subject to a condition subsequent? The important distinction between those two is that a fee simple subject to a condition subsequent with a right of re-entry means that the individual needs to go back into the property and reclaim the property. So it would mean that Hutton, when he realized that, oh my goodness, they're not using this for a school anymore, they're just making the Hutton storage facility, would need to go in there and reclaim it. And that can be done through a lawsuit. So that's the fee simple subject to a condition subsequent. If it was a fee simple determinable with a reversion, that would have been an automatic reverter. So as soon as the school district stopped using it for a school and started just using it as a storage facility, they no longer had a claim to that building, and it would revert back to the Huttons. So the court grapples with the language, and ultimately they decide that what the Huttons conveyed to the school district was a fee simple determinable. It was a fee simple determinable, and they based this off of the word only that's in the grant. They say land is to be used for school purposes only. And so they say that is enough to construe a fee simple determinable in this case. That rules in favor of the plaintiffs, the Marenholzes, because a fee simple determinable could be conveyed by Hutton to them, unlike a fee simple subject to a condition subsequent. So it seems like things are going in Marenholz's favor. This court doesn't deal with a few of the other issues that would be pertinent for the Marenholzes to reclaim this property. One, what are school purposes? That's the big key, is what are school purposes? And then just a few more facts to decide whether the Marenholzes really do have a claim to this property. So this court doesn't discuss that. This decision is mainly discussed in class and in the reading to understand a distinction between a fee simple determinable, a fee simple subject to a condition subsequent, and when we might be able to argue that something should be classified as a fee simple determinable, because that's favorable more often than a fee simple subject to a condition subsequent. So that's the case. Ultimately, after this case, there's another court case where the Marenholzes argue that this is our property, and the school puts up another argument saying that, hey, school purposes, that's a broad definition, and storing supplies also does constitute a school purpose. So the school district ends up winning, and they keep that 1.5 acres. So that's the case, and that's the afterwards, just so you kind of know what happened to both parties. Let's go ahead and jump into some ex ante implications. The first to discuss is how do we draw a line between honoring the wishes and the intent of the grantor and just the language that was written, right? Because this very easily could have just been a fee simple subject to a condition subsequent. And these classifications have very broad implications, and small wording changes in a deed or a conveyance could have massive implications down the line. Like if this was a fee simple subject to a condition subsequent, the Huttons wouldn't have had any claim, Mr. Hutton the heir, and the Marenholzes wouldn't have been able to really do anything in this case. So it's just something to think about is where does the law decide to honor the intent of the grantor, and where does it just look to the letters of the deed? And I think this case is actually pretty decent in recognizing the intent of the grantor, because the only language is not so often construed to be a fee simple determinable. We're looking more for language like so long, while, as long. So it does look to the intent of the grantor, and I think that's notable. But also, do we just want to look to the letters of the law of the deed? Is it just more simple for our legal process to look to the letters rather than try and assign some strange intent to someone that's passed a while ago? So something to think about there. How do we honor the intent of the grantor versus how do we look to the letters of the deed or the conveyance? So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. Hope you have a great rest of your day. Bye-bye.